My son called from the police station, "Dad, they're charging me with assault, and the detective says I have no alibi." When I walked into the interrogation room, the lead detective went pale and whispered, "Internal Affairs, Commander. I had no idea he was yours." The phone was in my hand before the second ring finished. That's a reflex you develop after 31 years on the job. The body answering before the mind catches up. It was 11:22 on a Friday night, and I was in my home office reviewing personnel files I'd brought home in a locked briefcase. The kind of files that have no business leaving the building, but that I'd been carrying back and forth for 3 weeks, because the investigation I was running had reached the stage where I didn't trust leaving anything in a drawer that other people had keys to. Isaac's voice, when it came through, was the kind of control that you only achieve when you are right on the edge of losing control entirely. "Dad." One word. The particular flatness of it, not panicked, not crying, just stripped of everything, told me before anything else that this was serious. He said he was at the 7th District Station on Faro Avenue. He said he'd been there for 4 hours. He said they were charging him with assault causing bodily harm, that the detective running the interview had told him his alibi was insufficient, and that he'd been advised to wait before saying anything further until he had representation. He said all of this in the voice of a 23-year-old who had been raised by a cop and knew how these rooms worked and was terrified anyway. I told him to say nothing. I told him I was coming. So I closed the personnel file that was open on my desk, and the name on the tab of that file, which I will get to in due course, meant something that I did not yet fully understand at 11:22 on a Friday night, but that I would understand completely by 3 o'clock the following morning. I put on my coat. I drove to Faro Avenue. I had spent 31 years with the city police department, the last 9 of them in internal affairs, the last 4 as commander of the division. Before that, I'd been a detective in homicide for 11 years, and a patrol officer before that, walking beats in the same neighborhoods where I eventually reviewed misconduct complaints against the officers who came after me. My name is Leonard Crane. I am 54 years old. I'm not the kind of man who describes himself in any particular way. But if you ask the people who had worked for me or against me over the years, they would probably say something about patience, that I moved slowly, thought before speaking, and was more dangerous in a quiet room than most people were making noise. I'd earned the IA commander position after a career that included 2 commendations, one serious injury from a vehicle pursuit in my patrol days that left a scar along my left forearm that I no longer thought about, and a divorce that was about the hours and not about anything else, or at least that's the version I'd accepted. My ex-wife Carolyn had remarried a high school principal named Gerald who was home for dinner every night at 6, and I had no animosity about it because I understood the math. Isaac was our son. We had shared custody through his high school years, and then he'd gone to university, and then he'd come back to the city and gotten a job as a junior architect at a firm downtown, and we had dinner together every second Sunday without fail. And that arrangement had been working well enough that I'd stopped feeling the particular guilt of the divorced father who missed the years and had started feeling something closer to gratitude for what remained. Isaac was a good person. He was careful and precise, the way architects are trained to be, but he was also warm in a way I'd always thought he'd gotten from Carolyn rather than from me. He had never been in a police station for anything other than visits to my office. He had never been in a fight, as far as I knew. Since a schoolyard incident when he was 12 that he'd told me about over Sunday dinner with the rueful amusement of a kid who'd lost badly and knew it. He was not the kind of young man who assaulted people. I knew this. I also knew that what I knew was irrelevant until the evidence confirmed it. The 7th District Station on Faro Avenue was not my district. I ran IA out of the Central Administration Building 4 miles north, and my oversight extended across all 8 city districts, but I didn't have a personal desk at any of them. When I walked through the front entrance at 11:58 p.m., the desk sergeant, a woman named Corporal Anita Belogan, who recognized me immediately, and whose expression shifted in a way that people's expressions shift when a senior official appears somewhere unexpected, told me my son was in interview room 2. She said it with a careful neutrality that told me she knew something about the situation that she wasn't going to volunteer. I thanked her and walked through the corridor toward the interview rooms, and I passed the glass-windowed observation room adjacent to room 2, and through the glass I saw my son sitting at a metal table with his hands folded, and across from him was a detective I recognized. The recognition was immediate and specific, and it produced a physical response in my chest that I can only describe as a sudden cold weight settling. The detective in the room with my son was Craig Mulvey. Detective Craig Mulvey, 11 years in the 7th District, currently assigned to the Violent Crimes Unit, and the subject of a personnel file that was sitting in my locked briefcase in the car outside, a file that I had been building for 3 months as part of a larger investigation into a pattern of evidence mishandling and witness intimidation across the 7th District that I had reasonable grounds to believe extended to at least 3 other detectives and possibly to a sergeant in the same unit. Craig Mulvey was the central figure in that investigation. His file was the thickest. And he was sitting in a room with my son, and I was standing in a corridor at midnight understanding something that I needed to be very careful about understanding out loud. I pushed open the door to interview room 2. Mulvey looked up, and the color went out of his face in a way that I have only seen a handful of times in my career. Not a gradual pale, but a sudden, complete draining, as if the blood had received an urgent memo and evacuated. He stood. It was an instinctive movement, not a respectful one. The movement of a man whose body recognized danger before his mind caught up with it. He said, "Commander Crane, I had no idea he was yours." He said it quietly, barely above a breath. In the room, Isaac had turned to look at me with an expression that contained relief and confusion in equal measure, and I understood that he didn't know, had no way of knowing, that the detective running his interrogation was someone I had been building a misconduct case against for months. That was a piece of information I could not share with Isaac in this room. I could not share it anywhere, yet. It was either the most compromising thing in the world, or it was exactly the leverage I needed, and I hadn't decided which yet, and I needed to think before I decided. And I needed to think faster than I normally allowed myself to. I looked at Craig Mulvey for a long moment and said nothing. He sat back down, slowly, like a man lowering himself onto uncertain ground. Isaac was watching us both. Let me go back to the beginning of the actual problem, because what happened at the 7th District on Friday night was the surface of something that had been building for the better part of a year. And understanding the surface requires understanding the depth. I had been running the IA investigation into the 7th District's Violent Crimes Unit since March. The initial complaint had come through our standard channels, a formal submission from a defense attorney named Gloria Ferreira, who had 14 years of criminal defense experience and a reputation for methodical documentation, alleging that evidence collected in a serious assault case had been improperly handled in a way that materially benefited a specific individual. The individual in question was a man named Rowan Bates, nightclub owner, long documented associations with organized figures in the city's West End, and notably, the kind of person who tended to emerge from serious criminal charges with inexplicable results. The assault case in question had been investigated by Detective Craig Mulvey. Though Gloria Ferreira's complaint was specific, the chain of custody for a crucial piece of physical evidence had been broken at the 7th District evidence locker, and the handling officer had been Mulvey. And the result was that the charge against Bates had been dismissed at a preliminary hearing for insufficient evidence. Gloria Ferreira had also submitted, as a supplement to her complaint, a screenshot of a bank transaction that she said her client, not Bates, but the assault victim, had uncovered during their own investigation. The transaction suggested a cash movement of $46,000 through an account connected to a shell company that her client believed was linked to Mulvey's brother-in-law. She was careful to frame it as alleged and unverified. I was careful to take it seriously. My investigator on the case, a sergeant named Philip Adeyemi, who had 6 years in IA and a talent for financial paper trailing that I had come to rely on completely, had spent 2 months tracing the shell company. What he found was meticulous and damning. The company had been established 14 months earlier, had received 3 cash deposits totaling approximately $80,000 over 8 months, and the registered director was indeed the brother-in-law, a man named Terry Osgood, who worked as a building contractor and whose declared income bore a limited relationship to the financial activity Philip had documented. The second and third deposits correlated, with uncomfortable precision, to the dates of 2 other case outcomes in the 7th District's Violent Crimes Unit that had also involved Rowan Bates, or associates of Bates. This achieving favorable results in circumstances that Gloria Ferreira was not the only attorney to have found puzzling. We were 3 months into the investigation when Isaac was arrested. The assault charge against my son involved an incident at a bar in the Merchant Quarter District, which falls within the 7th District's jurisdiction. On a Thursday night, 11 days before the Friday, I received his call. According to the arrest documentation I obtained that night from Corporal Balagan, and the word obtained is doing real work in that sentence, it's because she handed it to me with the look of a person who had been waiting for someone with appropriate authority to appear and take this off her hands. An individual named Drew Paxton had presented himself at the 7th District Station claiming he had been assaulted by a young man matching Isaac's description outside the bar in question. Paxton had photographs of bruising on his jaw and left ribs that had been documented by a medical examiner. He had provided a statement naming Isaac by first name and providing a general physical description. A bartender at the establishment had been interviewed and had confirmed that a physical altercation occurred outside the bar that night, but had not been able to clearly identify the participants from the doorway where he'd observed it. Mulvey had conducted the follow-up and had, through the bar's credit card records, identified Isaac as a customer that night. Isaac had, in fact, been at that bar. He confirmed this to me immediately when I spoke with him privately after asking Mulvey to step out, which Mulvey did with the careful compliance of a man making rapid calculations about his own situation. Isaac had been at the bar. He had left at approximately 11:15. He had taken a rideshare home and arrived at his apartment at 11:40. The alleged assault had occurred, according to Paxton's statement, at approximately 11:25, outside the bar's rear exit. The rideshare record, which Isaac had shown Mulvey, indicated a pickup at the bar's front entrance at 11:14. 11 minutes in a street-to-rear exit distance that would have been physically tight, though not impossible. Mulvey had characterized this as insufficient alibi and had formally recommended charges. The rideshare record was listed in the documentation, but Mulvey's report noted it without resolving it, which was a specific choice. I did not say any of this to Mulvey that night. I did not say much of anything to Mulvey, which I understood was its own form of communication. I got Isaac out on bail. The charge allowed for it, and the duty magistrate approved it at a brief hearing at 2:15 in the morning. And I drove my son home in a silence that lasted until we were 3 blocks from his apartment, and he said, "Do you know him? That detective? He looked at you like he'd seen a ghost." I told Isaac that I knew of him. I told Isaac that he should say nothing to anyone about the charge or the investigation until I told him otherwise. And that I was going to find him a criminal defense attorney by morning. He nodded. He asked if I thought the charge would go anywhere. I told him, honestly, that I didn't know yet. I told him that the rideshare record was significant and that I was going to pursue it. He nodded again. Then he said, in the voice of a 23-year-old who trusted me, but also knew me well enough to ask the uncomfortable question, "Is there something else going on here, Dad? Something I don't know about?" I kept my eyes on the road. "There might be," I said. "I'm going to find out." He got out of the car without pressing it further, because he knew me well enough to know that answer was as complete as it was going to get at 2:30 in the morning. I did not go home. I drove to a parking lot near the Central Administration Building, opened the locked briefcase on my passenger seat, and sat for an hour and a half reading Craig Mulvey's file in the light of my car's dome lamp. Philip Adeyemi had built it carefully. Incident reports, financial records, cross-referenced case outcomes, 2 witness statements from individuals who had been asked to modify their accounts of events and had instead, quietly and carefully, reported it to Gloria Ferreira and eventually to us. Everything in the file was preliminary. None of it was yet actionable at a criminal level. We were still in the investigative phase, still building the kind of documented record that would survive a defense attorney's scrutiny and a departmental review board's examination in the particular genre of counter-narrative that officers under IA investigation inevitably produced. We were perhaps 6 weeks from being ready to move. 6 weeks. And now my son had been charged with assault by the detective at the center of my investigation. The timing was either the most remarkable coincidence I had encountered in 31 years of law enforcement, or it was not a coincidence at all. I sat in the parking lot and thought about the distinction between those 2 possibilities until 4 in the morning, and then I called Philip Adeyemi and told him I needed him in the office at 7 and that he should bring everything. Philip Adeyemi arrived at 7:02, carrying 2 coffees and the particular expression of someone who had received an early morning call from their commander and understood it was not about scheduling, but he was 38 years old with a background in financial investigation that predated his police career. He'd spent 4 years at a forensic accounting firm before joining the department. And he was, in my professional assessment, one of the 3 best investigators I had worked with in 3 decades. He was also discreet in a way that wasn't simply professional discretion, but something more structural, a deep understanding that investigations live and die by what doesn't get said to the wrong people. I told him about the previous night. I told him about Isaac's arrest. I told him who had made it. Philip sat very still with his coffee cup halfway to his mouth. Then he set the cup down and said, in a voice with no effect whatsoever, "That's not a coincidence." I told him I agreed. I told him I needed him to tell me. With as much certainty as available evidence supported, whether the timing was operationally significant, whether Mulvey had reason to know, or could have deduced, that I was the investigating IA commander. Philip spent 20 minutes in silence reviewing materials on his laptop, and then looked up. "Bates's defense attorney filed a discovery motion 2 weeks ago in a civil case," he said. "Standard procedure, but the filing listed the IA investigation reference number. The reference number format includes the district of origination and the commanding officer's personnel code. It's not obvious, but if you know what you're looking at, And if you're the subject of an investigation and you're motivated to figure out who's running it, you could derive it. He paused. Mulvey's been on the job for 11 years. He'd know the format. The cold weight in my chest resettled. The timing was not a coincidence. Craig Mulvey had charged my son with assault 4 days after information was filed in open court that could have told him who was running the investigation into his conduct. My son had been used as a message. The criminal defense attorney I found for Isaac was a man named Solomon Ekwu, who had 20 years of criminal defense experience, including 12 years as a public defender before going private, and who I had never met personally, but whose name had appeared in my professional orbit often enough that I trusted the reputation. Solomon reviewed the charge documentation the same morning I called him, returned my call within the hour, and said, "What in the direct manner of someone who was not going to waste either of our time. The rideshare record is your foundation. 11:14 pickup, 11:25 alleged assault. The distance between the bar's front entrance and rear exit matters. What's the street layout?" I described it from memory. I had driven past the bar on my way to the parking lot the night before. He said he'd send someone to do a precise measurement and timing walkthrough that afternoon. He also said he wanted the rideshare company's raw GPS data, not just the receipt, and that he was going to subpoena it if necessary. He said, "The question isn't whether your son can be placed in the general area. The question is whether the prosecution can establish that he was specifically at the rear exit at the alleged time, and right now, they can't." He paused. "Who made the arrest?" I told him. There was a brief silence. "I know Mulvey," Solomon said. "He's testified against my clients twice. He's careful. The report leaving the rideshare record unresolved is unusual for him." That sentence confirmed what I already suspected. Mulvey was careful. He would know the rideshare record created a problem for the prosecution. Leaving it unresolved in his report wasn't an oversight. It was a door left deliberately open, enough to charge Isaac, enough to cause disruption, but not enough to actually withstand legal scrutiny if I played ball. It was leverage. The charge was designed to pressure me to slow down or shut down the investigation in exchange for it going away. The arrogance of that calculation was remarkable, and I understood it. Because I had seen the calculus before in officers who had spent long enough doing corrupt things that they'd lost the ability to accurately measure the risk. Mulvey had looked at my investigation and decided the tool was my son. He had miscalculated in one crucial direction. He had assumed I was a father first and an IA commander second. He had the order wrong. I need to be honest about what happened in me during the week that followed, because this story is not a simple one, and I am not a simple man, and the feelings were not clean. There was rage. There was a specific, particular kind of rage that I had never quite felt before. Not the professional anger of a law enforcement officer whose investigation had been interfered with, and not the institutional anger of a commander whose authority had been challenged. But the rage of a father whose child had been used as a chess piece by a corrupt detective who had calculated, correctly, that the child was a vulnerability. That rage was cold, and it was constant, and I carried it through the whole week like ballast, and it made me very still and very precise, which is what rage does when you've had 31 years of learning to work with it rather than against it. There was also fear. I will say it plainly because it is true. I was afraid for Isaac. The charge might have been designed as leverage rather than as a genuine prosecution, but criminal charges have a life of their own once filed, and I knew better than anyone how systems could move independently of the intentions that set them in motion. Solomon was excellent, and the rideshare data was promising, and the case for the prosecution was thin. But thin was not the same as absent, and my son was 23 years old, with a clean record and a professional career that would be materially affected by a criminal charge, regardless of how it resolved. The fear was real, and I let it be real, and I did not allow it to change what I was going to do. And then there was something else underneath the rage and the fear. A cold, specific clarity about the decision I was facing. If I accelerated the IA investigation and moved on Mulvey before we were fully ready, I risked compromising months of careful work and potentially giving Mulvey's attorney grounds to challenge the process. If I slowed it down to protect Isaac, I was exactly what Craig Mulvey had decided I was, a father who could be controlled. Neither option was acceptable. I needed a third one. The third option took me 4 days to construct, and it required the involvement of 3 people outside my immediate team. The first was Philip, who had already been working 14-hour days, and who responded to my revised timeline with an expression that suggested he had already been thinking along the same lines. The second was Gloria Ferreira, the defense attorney whose original complaint had initiated the investigation, and who had, over 3 months of professional interaction, become a trusted outside collaborator in the case. Technically unusual, but within the procedural framework because she was a complainant with documented evidence rather than a subject. Gloria had something I needed. Direct contact with 2 witnesses who had experienced Mulvey's pressure to modify their accounts, Almer and both of whom had indicated willingness to provide formal statements. She had been holding them in reserve pending our readiness to move. I called her and told her we needed to move the timeline. She was quiet for a moment and then asked if this was related to the assault charge she'd seen in the court filing system. I confirmed that it was. She said, "I'll have both statements in your hands by Friday." The third person I contacted was my own division's supervising counsel, a deputy city attorney named Yvonne Castellar, who had 25 years of prosecutorial and administrative law experience, and who served as legal advisor to the IA division for matters requiring formal legal guidance. I called Yvonne and described the situation with the careful precision of someone presenting a case. And when I finished, she was quiet for longer than Gloria had been. Then she said, "I need to tell you something before we go further, Leonard. The moment your son's name appears in a charge originating from the subject of your investigation, you are in a conflict of interest situation that requires documentation and oversight. You cannot run this investigation to its conclusion without independent review. You know that." I told her I knew that. I told her I wanted it documented. I wanted everything documented. I wanted a formal record showing that I had disclosed the conflict, sought independent oversight, and taken no action in relation to the investigation that hadn't been reviewed and authorized by her office. There was a silence on the line, and then Yvonne said, "You're not trying to slow it down." It wasn't a question. "No," I said, "when I'm trying to make sure it holds up." She made a sound that in our working relationship I had come to recognize as professional respect expressed with maximum efficiency. "Get me everything," she said, "today." The investigation moved in 2 tracks simultaneously during the following 8 days, and the discipline required to keep those tracks separated, the IA investigation on one side, Isaac's defense on the other, was the hardest professional work I have done in 31 years. I had to conduct myself in relation to the IA case as if my son's situation had no bearing on my judgment, which in terms of process was true, and in terms of psychology required a level of compartmentalization that I only managed because Philip was running most of the day-to-day operations, and I had structured my oversight role so that the key decisions were being made by Philip and reviewed by Yvonne rather than driven directly by me. What I contributed in those 8 days was the piece that only I could contribute, which was institutional knowledge. 31 years of understanding how the department worked, who knew whom, where the informal power structures ran, and where Mulvey was most likely to have made his mistakes. Corrupt officers, in my experience, always made their mistakes at the intersections, the points where their off-book activities had to interface with official systems. You can control what you do in the dark. Or you can't fully control the paper trail that legitimate police work generates, and that trail always touches the dark activity at some point. In Mulvey's case, the intersection was the evidence locker. Philip had been building the chain of custody documentation for months. What I added in those 8 days was a review of the locker's access logs that had been sitting in our file unanalyzed, 40 pages of timestamps and badge scans that nobody had yet mapped against the relevant case timelines. I stayed in the office until 2 in the morning on a Wednesday night going through them page by page, and I found on page 31 an access timestamp that corresponded to a time when Craig Mulvey's own case file showed him as being in a court appearance across the city. He had accessed the evidence locker at 3:42 p.m., when he had signed into the courthouse for his court appearance at 3:15 p.m. and been logged out at 4:10 p.m. Logistically, with city traffic, it was not possible. The badge scan was either an error or it had been made by someone else using Mulvey's access credentials. Either possibility was significant. Philip reviewed my findings the following morning and added them to the file with a notation that I thought, reading it, was one of the most restrained pieces of professional understatement I had encountered. Access log discrepancy requires reconciliation prior to formal submission. That sentence meant, we have him. Solomon Ekwu filed a motion challenging the sufficiency of the assault charge on a Thursday morning, attaching the raw GPS data from the rideshare company, subpoenaed 3 days earlier, along with a supplementary analysis from a licensed surveyor who had done the street measurement walkthrough Solomon had ordered the week before. The surveyor's analysis established that the distance between the bar's front entrance and its rear exit, taking the most direct pedestrian route, required a minimum of 3 minutes and 40 seconds of walking time. Isaac's rideshare GPS showed his phone's location at the pickup coordinate at 11:13 and 52 seconds. If the assault occurred at 11:25, as Paxton had stated, Isaac would have needed to exit through the front, walk the full distance to the rear, commit an assault, and then by some mechanism the prosecution had not specified, returned to the front in under 12 minutes, which the surveyor noted was technically possible, but required a pace inconsistent with normal pedestrian movement and left no margin for the altercation itself. More significantly, the rideshare driver's own GPS, included in the raw data, showed the vehicle arriving at the front of the bar at 11:13 and departing at 11:15, with a passenger in the vehicle for that entire window. The assault allegedly occurred while Isaac was already in the car. The prosecution's case was not thin. It was gone. The district attorney's office, reviewing Solomon's motion, declined to pursue the charge. The notification came through at 4:55 on a Friday afternoon, 12 days after the original arrest. What Solomon called me before he called Isaac, which was a professional courtesy I appreciated, and told me with the satisfaction of someone who had enjoyed the work. Dismissed. No further action. I thanked him. I sat at my desk and allowed myself 30 seconds of something that was not quite relief. Relief implies the threat had felt manageable, and it had not felt manageable, but was adjacent to it. Then I picked up my phone and called Philip. "How are we doing?" I asked. Philip said, "We're ready." The formal submission to the city prosecutor's office was made on a Monday morning at 9:15, with Yvonne Castellar present as supervising counsel. The submission ran to 412 pages, inclusive of exhibits, and covered 3 distinct areas of alleged criminal conduct: evidence tampering in connection with the Bates assault case, financial misconduct involving the Shell Company and the payments to Terry Osgood, and witness intimidation in connection with 2 documented incidents in which individuals had been pressured to modify their accounts of events. The 2 formal witness statements that Gloria Ferreira had delivered as promised on the previous Friday were included as Exhibits F and G. The access log discrepancy was Exhibit L, supported by the courthouse sign-in records, the badge scan timestamps, and a technical analysis from the department's IT forensics unit confirming that the badge scan had been made using Mulvey's credentials, but with physical characteristics: angle of approach, duration of scan that differed from his established pattern of use, suggesting the credential had been used by a second party. That finding was Exhibit M. The financial records, cross-referenced against the case outcome dates, were Exhibits A through E, and Philip had organized them with the obsessive clarity of someone who wanted the prosecutor to be able to follow the money without taking a breath. Craig Mulvey was suspended from duty pending investigation at 10:40 that same morning. The suspension was delivered by the 7th District's own commanding officer, Deputy Chief Anselm Ofegbu, who had been briefed by Yvonne the previous Friday, and who I knew from 31 years on the job. I had suspected something was wrong in the Violent Crimes Unit for longer than our investigation had been running and had not been able to act on a suspicion he couldn't document. He documented it now. The suspension was immediate, with a directive to surrender credentials and service weapon. Mulvey was accompanied out of the building by 2 officers at 11:05 in the morning. A second suspension for Detective Ray Farland, the officer Philip's investigation had identified as likely being the person who had used Mulvey's credentials at the evidence locker, followed 30 minutes later. The wheels of formal process are slow, and what comes next in these cases takes months, sometimes years, and the outcome is never guaranteed, even with strong evidence. I know this better than anyone. I have been on the institutional side of this process for 9 years, and I understand its weight and its limits. But the morning of those suspensions was the morning the leverage dissolved. Whatever Craig Mulvey had calculated when he filed assault charges against my son, whatever equation he had run about the vulnerability of a father, about the pressure he could apply, about the trade-off he was offering, it ended that morning when his credentials were surrendered and he was walked out of the 7th District station on Faro Avenue through the same corridor where my son had sat in interview room 211 days earlier. I called Isaac at noon. He answered on the first ring, which told me he'd been waiting. I told him the charge had been dismissed. He already knew. Solomon had called him, as was appropriate. I told him something more, something that I had decided, carefully, to tell him rather than protect him from. I told him that the detective who had charged him had been suspended pending investigation for evidence tampering and financial misconduct, that the charge against Isaac had been, in my assessment, an attempt to apply pressure to an IA investigation, and that the attempt had not worked. There was a long silence on the phone. Isaac said, "He used me to try to get to you." It wasn't a question. I said yes. He was quiet for another moment. Then he said, in a voice that sounded less like the controlled young man from the police station and more like my son, "Did you hesitate when it was me?" It was the honest question, and it deserved the honest answer. I told him no. I told him I had been afraid for him and furious about what had been done to him, and that neither of those things had changed what needed to happen, because the moment I let a corrupt detective use my son to alter the direction of a legitimate investigation, I had made a choice about what kind of institution we were and what kind of officer I was, and I was not willing to make that choice in that direction. He was quiet again. Then he said, "Okay." Just that. "Okay." And I understood it as a complete answer, not agreement exactly, but acceptance. He said he'd see me on Sunday. I said yes. The broader investigation into the 7th District's Violent Crimes Unit continued for 7 months after Mulvey's suspension. It eventually encompassed 4 officers in addition to Mulvey, produced criminal charges against 3 of them: Mulvey, F. Farland, and a 3rd detective named Gordon Wash, who had been identified through the financial records as a secondary recipient of funds from the shell company, and resulted in the civil service termination of all 4. Terry Osgood, the brother-in-law who had managed the shell company, was charged with money laundering as a separate matter and pleaded no contest in a deal that required his full cooperation and testimony in the criminal proceedings against Mulvey. Rowan Bates, the nightclub owner whose favorable case outcomes had generated the original complaint, was recharged in the assault case that had been dismissed due to the evidence mishandling, and that case was still in process at the time of this account. Gloria Ferreira, who had started this chain of events by filing a complaint with enough documentation to be taken seriously, received a formal letter of acknowledgement from the city attorney's office that I understand meant a great deal to her, though she was too professionally composed to say so directly when I saw her at a procedural hearing 3 months after the submission. Drew Paxton, the man who had claimed Isaac assaulted him, was interviewed by detectives not from the 7th District on my specific request and declined to cooperate with any further inquiry. No charges were filed against him for false reporting, which was a limitation of the available evidence, and which I accepted as one of the unsatisfying realities of the process. Philip Adeyemi was promoted to lieutenant and is now running a team of 6 investigators in the IA division, that which is the outcome I had been building toward for 2 years, and which I can say without false modesty was deserved. On the Sunday, 4 days after Mulvey's suspension, Isaac came for dinner. I cooked, which I do with limited range, but genuine effort, and we ate at the kitchen table with the radio on in the background. And at some point, Isaac put down his fork and said, "Can I ask you something?" I said yes. He said, "When you walked into that room and saw him, Mulvey, and realized what he was, what he'd done, were you angry?" I told him I was. He nodded. He was quiet for a moment, looking at his plate. "You didn't show it," he said. "In the room, you were completely still." I told him I'd had 31 years of practice. He almost smiled. Then he said, "I think I understand your job a little better now. I think I understand why you are the way you are." I asked him what way that was. He looked at me with the directness of a young man who has had a week to think about something important. "Careful," he said. "You're careful. Not in a small way. In a big way. Like you know that everything has weight, and you're very deliberate about what you put your weight behind." He picked his fork back up. "I didn't always appreciate that when I was younger. I thought it meant you were distant." The radio played something quiet in the kitchen. Outside, it was a cold November evening with early dark. "I was sometimes distant," I said. He shrugged. "Maybe, but I understand it now." We finished dinner. He stayed until 9, and we watched part of a film that neither of us was fully paying attention to, and when he left, he hugged me at the door, which is not something we do with any particular ceremony, but which felt, that night, like something with weight behind it. I stood in the doorway after his car disappeared and thought about the file on Craig Mulvey that had been sitting in my briefcase on the night my son called me from a police station on Faro Avenue, and about the calculation Mulvey had made when he decided that a father's love was a weakness he could exploit. He had looked at what I was and seen the vulnerability. He had not seen the foundation. They rarely do. The ones who rely on other people's pressure points. They see what can be used, and they miss what cannot be moved. I went inside. I locked the door. I had paperwork to finish and a full week ahead, and the quiet and the specific satisfaction of a man who has done exactly what needed to be done and can live with how he did it. That, in the end, is the only currency I know how to spend.